Right, thank you. Good morning, everybody. It's 10 o'clock, so the hearing's now open. My name is Rosie Morgan, and I've been appointed by the Secretary of State to conduct this hearing this morning into appeal by Riverside Caravan Park. Is it? Is it okay? Is it just a bit of feedback? Yeah, okay. Okay, so this event's being live streamed, so I've got the microphone on. Has anybody got any objections to recording of the event? No. So if you can switch the microphone on when you're speaking and then turn it off when you're not speaking, that please. So we've already had the fire alarm, so we're not. So I guess if the fire alarm goes off again, then that means that we need to leave. Could you, and where's the exit, please? That one. Okay, thank you very much. Thanks. Right, has everybody got a copy of the agenda that was circulated? Yep. Yeah. Okay, great. Thank you. Right, and if everybody could switch your phones off or turn them on to silent, that'd be great. Thank you. So can I just take everybody's names to begin with? And start with the council.
Yep, Gavin Taylor.
Gavin Taylor. Thanks. And for the appellant?
I'm Nick Leister from Leister Planning. Bob Neville from Leister Planning.
Thomas Murphy from Riverside Park.
Thank you. So the session today will be a structured discussion, which I'll lead with questions. The aim is to let you all put forward your points of view and just to enable me to get the information that I need to make a decision. I'm not anticipating it's going to take too long to get through everything. We should hopefully finish this morning. I have already been and had a look at the area around the site yesterday. I had a walk around the area, but I suspect it probably will be useful to, after the event, after the hearing today, go and have a look on the site itself. But we can talk about that later. But I'm intending to finish the hearing today. So at the site visit later, there wouldn't be any further discussion. It would just be to have a look at the site. That'll be all. Okay. So we'll talk about that later. So I've read all the written statements. There's no need to repeat material. You can draw my attention to something specific. And I will give just as much weight to written evidence as to oral evidence. So I'm assuming that I have had all the information and evidence already. If there's any, I'm not inviting any late evidence, but if there is anything, can you let me know now? Okay, thank you. Thank you for providing the signed statement of common ground, which has got a list of conditions, and we'll have a brief discussion about that later. I'm not aware of any cost applications. Well, I'm not inviting any, but if there's any to be made, can you do that here at this venue before the site visit? Okay, right. Great. Right, any questions about the procedural side of things? No. Right, okay. In that case, we will start off with the second item on the agenda, plans and documents. I've included a list on the agenda, schedule of plans and documents. Actually, that should correspond as well with the one that you've included on the statement of common ground. So, but if there's anything on there that doesn't look right, or if I've missed anything, you could let me know.
We're happy with it.
Okay, thanks. So the planning policy for the area, East Cambridgeshire local plan. I've written those a list of the policies that I thought were likely to be the most pertinent to our discussion this morning, and there's obviously others that are relevant in terms of conditions as well. Is there any change to the policy position that I need to be aware of?
No, there's no change to those policies.
Okay, thank you. And reference has been made to the Littleport master plan. Can you just let me know what the status of that document is, please?
Yeah, sure. So the Littleport master plan was essentially endorsed, adopted by the council back in 2011. It was a vision essentially for Littleport going forward and its growth aspirations. Essentially, it then informed policies of the local plan, which I think the Littleport policies set out that obviously the Littleport master plan informed some of the growth direction for the Littleport policies. In terms of its status, it has no, essentially has no statutory position in the development plan. And obviously, it's considered that the local plan is the sort of primary, the policy which steers growth for Littleport. So very little weight given to the Littleport master plan. Okay,
thank you. But it has been, if its aspirations have been translated into the development plan, it has. That's that's the way that it has weight then.
Yes, essentially the policies that are informed by the Littleport master plan are housing and employment growth.
Right. Okay. Thank you for that. Okay. Any other policy matters anybody wants to comment on?
No.
Okay, so the main issues that I've identified are whether there's a need for the proposed holiday accommodation in this location and the effect of the proposal on the character and appearance of the area. Any comments on those as a?
We're happy with those.
Yeah.
Yeah, but no further comments.
Okay, thank you. Okay, so start off then looking at the first main issue on in relation to need. Just before we go into that in any detail, can I ask the appellant just to provide some sort of initial context? Can you just give a brief overview of the existing business and the reason for the proposed additional accommodation now? Sort of just a bit of background.
Yep, that's fine. Yeah, so the business has been owned by our client for a few years. I think it was about 2016, 2017, I think, is that it was acquired. And obviously the existing business has a what you might call a open or unrestricted planning permission situation where caravans up to 49 caravans can be stationed for any purpose. So what's happened over the last, I suppose, in the years running up to COVID, is that there was more demand at the time, it seemed, for occupation of caravans for residential rather than holiday. So at the moment, there's 7 holiday caravans on the site, and the balance are people who are occupying them on a permanent basis. But what happened really post-COVID is, and this happened to, I mean, I work for a large number of holiday parks around the UK. That's my specialist area, so all over the country, literally from Scotland right down to Cornwall. And one thing I've noticed, it's not just on this site, is that since COVID, there's been a much greater demand for holidaying in the UK, staycations, and that's at every level. That's found by our big operators, as well as sites like this with the smaller operators. So what they've found is that since COVID, the demand for holiday accommodation has grown significantly. And that's why one of the primary reasons for wanting to develop the park more for holiday. So there's no plans for any more of the existing units to be sold for residential. They're going to be retained for holiday. There are some units up for sale, and that's picked up in the council's statement, but they're privately owned units. They're units that, so the way the site has worked up to now is that the residential units have been sold to private owners, and obviously that's their caravan. They own the caravan. They pay a fee to be on the site every year. So as long as they pay their fee, that's their caravan, and they're protected by a site license as well. So the residential occupants, they can't be kicked off the site for any, we couldn't kick them off the site to say, we want to put some more holiday units in there. So those ones that are on the market are private owners selling through estate agents, basically, which our clients has obviously got no control over. But the remaining units are holiday, and and that's how it runs at the moment. And the future units, if we're successful here to get the additional 10, they will be used for holiday. And obviously, we'll come on to that. We'd expect them to be conditioned as such as well. As always, there's no justification for residential in this location. Our client knows that.
Okay, thank you. So just to clarify then, the 7 on the existing site that are holiday accommodation, are they not privately owned then? Or?
Yeah, so the 7 that are on the existing site are privately owned holiday units. And what the owners do, I think you can see that from one of the letters actually, what the owners often do is sublet. So they're almost like little mini businesses of their own. They buy a holiday unit for their own holiday use, and then when they're not using it, they can sublet via the park itself for holidays. That's how the 7 are run.
So they're like people's second homes, effectively.
Yeah, they're people's second homes, which they can use for holidays, and then when they're not using it, they can be let out to other people who aren't. That's a fairly standard model. Most caravan parks use that. So if you're buying a holiday, if you book a holiday, you wouldn't know as the holidaymaker booking that you're actually holidaying in somebody else's private caravan. That's sort of invisible to the person that's booking. It's a fairly standard model across most caravan parks.
Okay.
Just to follow up on that, we did contact all of the owners of the caravan park just to get letter of confirmation that they were being used for holiday units. 4 of those people have responded, and that is Appendix 10 of the statement of case.
Okay, thank you. So I've seen that. So can I just make sure I'm understanding this right? So are all of the units then in private ownership, and most of them are occupied on a permanent residential basis, but some of them are, the 7 are effectively like holiday homes. But presumably, just let me know if I'm not understanding this right. The other ones that are in private residential use, including the ones on the market, presumably, am I right in thinking that they could be used for holiday accommodation in the same way? Is there any difference? I suppose I'm trying to understand. Is there any difference between the 7 and the other 42 that are in private residential use in the way that they're kind of operated?
Yeah, there's no real difference, and because the units are all the modern units are built to British standard, which is basically it's a standard that's used for caravans that includes residential caravans. So they have the right, so that, for example, they have the suitable insulation and sort of energy performance. So the caravans can be used for holiday or residential. So the people who've own a caravan have put them on the market. They could either be bought by somebody who wants to live in them, or they could be bought by somebody who wants to use them as a second home. Obviously, we've got no control over that, but it's open to them to do that.
Okay, thank you. And the ones that have been on the market recently, do you know if they sold as have they sold as permanent residential? Do you know how they're being occupied?
Yeah, so I think some, because there's units that come and go, but there's some have been sold for residential and some have been sold for 12-month holiday. So they can be used for holiday, but all year round, where people would have another home to go to, even though there's no requirement. Obviously, as there would be with a standard holiday condition to demonstrate there's another home, but some of them are sold for 12-month holiday use. But at the moment, the current status is that there's around about 7. But I think that fluctuates. I think the way things are going, certainly my experience with other parks, at the moment, the way things are going, there's probably a shift more towards the holiday side than the residential, just because of the way things seem to be working with COVID is that obviously holidays abroad are coming back, but there's a new sort of, and a lot of that data we presented in our report, which is there's a new sort of baseline of UK holidays, which is higher than 2019. So there's a proportion of people now who either don't go on foreign holidays or go on shorter foreign holidays and spend holidays in the UK. So the expectation in the industry is that the holiday side is always going to perform better than it did pre-2019. And that's certainly borne out by the statistics. And new statistics are received all the time. Obviously, some of them are beyond the deadline of this, but there was Visit England statistics came out last week, which again showed further increases in holiday, which is above the sort of pre-2019 period. So I'm fairly confident that we're not going to go back to, in a similar way to pubs and things, pubs and cinemas have settled down at a lower level than pre-2019, whereas UK holidays and also outdoor attractions, open air attractions like farm attractions. So we act for a lot of theme parks and farm attractions around the country. They've all settled down to a higher than pre-COVID level. Main reason being they're outdoors. I think it's basically indoor venues seem to have suffered long term. So the sites like this are a beneficiary really of COVID long term, is that they're benefiting from that slightly higher level that's likely to be here to stay.
Okay, thank you. Probably come back to some of the points as we go through the discussion. Can I ask the council now, in light of that discussion, and the written evidence as well. Can you explain how policies growth 2 and EMP 8 relate to the proposal?
Yeah, sure. So obviously growth 2 is concerned with sort of locational strategy of growth across the district, with obviously the main aim, I guess, is to protect the countryside, but obviously allowing for those exceptional types of development, tourist development being one, obviously. EMP 8 itself is, the main focus for this development proposal in terms of tourist accommodation, and obviously it sets out some criteria there that need to be met in order for that development to be supported. So essentially, EMP 8 is basically underpinned by growth 2 and that need to, well, the allowance of some development, but with that need to protect the countryside. So EMP 8 essentially takes on tourist accommodation and sets out that criteria as was set out in EMP 8. The first one being obviously need for that additional accommodation being justified. Obviously, its relationship to the sort of nearest settlement, I guess, and then obviously impacts on character and appearance, again, with that overarching need to protect countryside. So in terms of sort of the policy, full weight is obviously given to EMP 8 in terms of how the approach is taken to justifying development in those countryside locations.
Okay, thanks. And so obviously there's disagreement about the first criteria of EMP 8, the need, and the third one. Can I just clarify in terms of the second bullet point? Is my understanding that this site's outside the settlement boundary?
Yes, it's about 250 metres away from the settlement boundary of Littleport. Yeah. Does
that run along the other side of the river then?
Yeah, so the river essentially divorces this site from the Littleport settlement. So
in relation to the policy, it requires that proposals are located within or well related to an existing settlement boundary. What's your view on that element in relation to the proposal?
So obviously it's rural tourist accommodation. I think there would have to be some acceptance to a degree that some of the rural tourist accommodation may not be fully supported by cycle and pedestrian routes. In terms of access to the main settlement, my understanding is you can exit the site, cross the Riverbank Road, and up onto the public right of way that runs along the bank, and that will take you into Littleport. So in terms of its sort of link, it's how well related it is. It's outside the settlement boundary, but obviously growth 2 doesn't completely discount that. And the access could be achieved, albeit somewhat restricted in terms of the fact you would have to cross that road and walk up the steps to the bank and walk along essentially an unmade track to the centre of Littleport.
Okay, so in terms of whether it's well related to the settlement boundary, and this isn't something that you particularly raised, I just wanted to make sure that I understood your position on it. So your interpretation of that bullet point is that well related is to do with access. Is that right?
Yeah, I think it's obviously it crosses over several things. Obviously, there are already bullet points there in terms of character and appearance. So perhaps it's not necessary to sort of consider that as part of the relationship, but I would consider it's more towards sort of sustainable transport modes.
Okay. And so So you're not suggesting there's any conflict with that particular part of the policy then?
Not that would be sufficient
okay,
to
that's
warrant
fine.
refusal, I wouldn't say.
Okay, great, thank you. Do you want to say anything about that?
Sorry, main market towns, which include Littleport. And obviously there is an exception that outside of those development envelopes, development will be strictly controlled, but development will be and development will be restricted to the main categories that are listed in the bullet points of growth 2, providing there is no significant adverse impact on the character of the countryside, which obviously we're going to come to later. And one of those bullet points in growth 2 is tourism development, and then it refers to EMP7 and EMP8. And we agree with the council that EMP8 is the primary policy against which this proposal should be considered. Just draw your attention to in the introductory text just before EMP8, there's 2 paragraphs that are of particular relevance to this proposal. One is 5.9.1, which is the first paragraph, which talks about this is an attractive destination for day visits and an increasingly popular destination for overnight stays. And then it says, the second sentence of that paragraph, there is a need for additional tourist accommodation, particularly within the hotel, caravan and camping sectors. So it's identified in the first paragraph, introductory paragraph, as being, I know there's no disagreement between us and the council on that there is a need, but I just wanted to draw to that attention. It also says in paragraph 5.9.4, and I don't believe, we may not have drawn your attention to this in our appeal statement, which is that it says that all tourist accommodation should be located within settlements where possible. However, there's a however, and that's for caravan, camping, marinas and moorings. So obviously caravan is where we fall. It is recognised that locations on the edge of settlements may also be appropriate. And also where schemes are proposed as part of the expansion of existing accommodation. So we would fall within that. We do consider this edge of settlement. Yes, it is separated by the river, but you can walk out of the caravan park. There is actually some steps up onto the embankment pretty much opposite the caravan park. So then you can walk along that embankment. It then turns into a footway. Just before it gets to the bridge, it turns into a proper tarmac footway. And then you can obviously turn and go over the bridge, and then you're in Littleport. So as in terms of location and sustainability, this has got to be one of the most sustainable locations at which you can put an extension to a caravan park. You know, most caravan parks, there aren't that many, as we found out in our study. Our needs study showed there is actually quite a low level of caravan parks, particularly those that include lodges and static caravans in this area. And that's certainly something that came out of our own study, as well as being recognised in the local plan, that there is a need for caravans. But from our perspective, we think this is an example that falls within that, being close to the edge of a settlement, as close as you can reasonably get, whilst being along the riverside. And of course, that was something as well that was picked up in that, certainly in terms of background context, it was picked up in the Littleport master plan about focusing tourism developments along the riverside frontage, because that's where they saw the best, makes sense, the best opportunity for getting people to stay in the area is to put it along the riverside. It's the obvious place. I mean, caravan parks and holiday parks work better alongside lakes, rivers and the coast. That's a sort of fairly tried and tested. So we get that. So we feel that we fall within EMP8, and where it says proposals for new or extended caravan lodge, etc. sites will be supported. So the starting point of EMP8 is that these are supported. So as long as we meet the criteria, and obviously as far as I can see, the first bullet point, which talks about the need for additional accommodation, can be justified. And that's obviously your first main issue. I actually don't think there's anything between us and the council on that. I think that we are in agreement. Certainly in the statement of common ground, it agrees that we all agree there is the development will introduce additional tourist accommodation where there is a known need for such accommodation. That's obviously mentioned in the local plan. It's in the statement of common ground, and we agree that there is a need.
Okay, thank you. I don't think I've actually got a copy of that first paragraph you referred to, because it's given you get sent extract of the policies with the text, so I haven't actually got that 5.9.1. Would it be possible to just have a copy of that? The page that's got that paragraph in it from the plan. Would that be okay?
Yeah, it's pages 61 and 62. Those two paragraphs, they go across 2 pages. So pages 61 and 62.
I've got 62. I just haven't got.
Right. So you've got
it's
5.
just,
Right.
Yeah,
You've got 5.
it's just the it's just 61.
Right. Great.
Okay. Yeah. Thank you. Thank you for that. Can I ask the council then, following on from that, can you explain what your position is in relation to need, and how you see I suppose the wider need, and then if you've got any other comments in relation to this particular proposal?
Yeah, so I think we are in agreement that there is a need for tourism accommodation across the wider district, and that Littleport would benefit from additional tourist accommodation. The concern is essentially whether this site is suitable to support that need. Given, I think we probably agree it's, in terms of how it currently operates, is quite complex to understand. My understanding, we've got sort of 7 holiday units that we know operate, that leave the remaining where we're not quite sure whether they operate as holiday units or not, and therefore the concern is whether there is a need, a demand and a need in this location that can be supported, i.e. would it be well utilised, or is there a reason why we now only have a site with sort of 7 known holiday units, with the remainder sort of privately owned, uncertain as to whether or not they are used for sort of tourist accommodation as it is here. So the concern is obviously that this, the proposal would result in incursion into the open countryside, and with uncertainty as to whether or not actually there is a need in this specific location, in terms of would it be well utilised, or actually would it be development that is unjustified and creating that harm to the countryside which the council set out. So I think whilst we accept there is a need for tourist accommodation in the district, and that Littleport would benefit, the concern is whether that need would be satisfied in the long term by this site.
So if it was a brand new site in this location, that's treated in similar way. Is that treated in a similar way in policy, or is there any difference?
Yeah, no, I think EMP8 is for new and existing expansion for tourist accommodation. Yeah. So your concerns about it, you accept as a general need, but I suppose because of the sort of the history and the way that the existing sites operated and been evolving, that's given you cause for sort of doubt about the need demand. Is that my understanding? Yes, that's right. Yeah, I mean, essentially, we have to accept that all development is harmful to a degree, one way or the other, and we've got to protect the countryside. And therefore, if this were to be allowed, permitted, we've got to consider whether that harm is justified as set out in the policy. And the concern is that we have a site which over time has reduced its amount of tourist accommodation. I take on board, the appellant's comments in terms of sort of post-COVID, and then the expected level of staycations, etc. But the concern is there a reason why over time the tourist accommodation on this site has reduced down to what we know is only 7 units out of the 49? And I appreciate maybe some of those remainders may well be used for holiday accommodation, but we're not certain by the looks of it. And therefore, is there a demand that would support that need in this particular location?
Thank you. Do you want to respond on that point, please?
Yes. So what the council seems to be saying is that because the planning permission that was issued on that site, which obviously was issued to the previous owner, not the current owner, the original planning permission is from some time ago, that this site should somehow be treated differently if there's a wish to expand the holiday side. I mean, obviously, when our client acquired it in 2016, there was already a large number of residential people on the site, living on the site. And so a lot of that was inherited. And so, there's a historic element to it. It was an old planning permission, and it probably wasn't drafted as well as a modern permission would be drafted, which ended up leaving a situation where it was clarified that the permission would allow for holiday or residential. But so in terms of in policy, I don't think we can really, how the council granted a permission many years ago. I don't think that, and because our client inherited quite a few residential occupants, I don't think that should have an impact on how you look at a new application, because firstly, it's a good location. It's by the river and it's right next to the settlement of Littleport, and you can walk, cycle into Littleport easily from the site. So it's a highly sustainable location. You can take use of all the services and facilities. But the policy obviously allows for new or extended sites. I think there was a misunderstanding as well when we said in our statement of case that it could be a new site. It would meet a policy. The policy would allow it if it was a completely new site. We weren't saying, and that then triggered some comments about flood risk and the sequential test. We weren't saying that we are treating it as a new site. We were saying that if it was a new site, it would still be acceptable under policy EMP 8, because that allows for new or extended sites. But just to clarify, we are an extension to the site. It is going to be operated, it's one business, operated by one person who's here today. And the new site will just be an extension of that exact same business. It will be accessed through the existing site, over the bridge, so it will all operate as a single site. There's a reception when you go onto the site. It'll all be operated from the same reception. So there'll be no difference in that respect. So it definitely meets the criteria as an extension. So we're happy that the site's an extension, that it fits within policy EMP 8, that it is well related to. So it follows the EMP 8, which says within or well related to. I don't think any sort of objective assessment of this site's location could conclude anything other than it's well related to Littleport. And there is a need, and I don't believe we've heard anything from the council today other than confirming that there is a need for a development for additional holiday static caravans or little caravan lodges in this location.
Okay, thank you. So I think you said this before, but can I just clarify how the new units, if the appeal were to be allowed, how would they be owned by the holiday park and then rented out centrally in a different way than the existing site operates in terms of so just going back to that, how it would operate?
Yes, so as I was saying earlier, a lot of caravan parks, most caravan parks have the model where they'll have a proportion of what they call fleet units, which are ones they rent out. And then they'll have owned units, which are ones that are holiday homes, but privately owned, but they can then be sublet out. So the idea of this development is that these units will be acquired by the park itself and installed, and then rented out for holidays. So then he's got a good mix on the site. You've got the residential units, you've got the privately owned holiday units, and then you've got the units that are owned by the actual park itself, which will be the 10 new ones. So it would make this business will be very similar to most others. It would have that mix, which is standard across the holiday park industry, as I say, with large companies. I mean, we act for people like Bourne Leisure Haven, Park Holidays, the big boys. They do the same thing, and most of the smaller companies try and have a similar model, which is the intention of this particular part of the development.
Okay, thanks. And the shared facilities, would there be others? Are there other shared facilities on the site? Other than you mentioned they'd have shared access and shared reception. Are there any other linkages with the existing site in terms of facilities?
So let me just, as far as I'm aware, that you've got the same entrance, you've got the same reception building where you check in, and you go through a barrier, and that's basically it. There's no on this site, there's no sort of entertainments or clubhouse. The idea is that people, because it's in walking distance of Littleport, the idea is that people use the restaurants and the pubs and etc. in the town. But I'm just going to double check that I haven't missed something out on the site. Yeah, so it's about a year to 18 months since I last set foot on the site, so I just thought I'd better check that nothing had changed. But no, it is just the entrance, the barrier, the check-in, the reception is the facility that is shared, will be shared by both sites. So they will operate as a single entity essentially.
Okay, thank you for that. So can I go back to the council? Sorry, in relation to, so following the discussion this morning about how the site has evolved and how it would be run, is there anything else you want to add in terms of sort of the need and the concerns that you've expressed?
No, I don't think so. I think it's sort of clarified in terms of those shared facilities. Obviously, there's a proposal for a maintenance building to be well, a building to be reused for a maintenance building on site. But I appreciate, given that obviously the holiday units on site are privately owned at this time. Obviously, they probably wouldn't need to rely on a maintenance building, so that sort of clarifies that for me.
So in relation to the need for the facility in this location, is your concern still in relation to the existing site and whether there actually is a genuine need?
Yes, I think in terms of I think the council does have concerns in terms of the overall demand for units in this location, and therefore obviously the need because of how the site sort of operates. Obviously, we're mindful of a certificate for lawfulness that was submitted in 2020 for 55 caravans, unrestricted as well, which showed obviously a different approach. But I appreciate we're in time now, perhaps post-COVID, where I guess commercially, perhaps the situation has changed somewhat. But I think the council will still have concerns that there may not be a demand for these units in this location, given how the sort of site's evolved, appreciating it's only been taken on the last 7 years or so. But nonetheless, I think we'd still have concerns that even in the time that the appellant has owned the site, there has been an approach to increase the number of unrestricted caravans on the site through that certificate of lawfulness. But that said, I have to acknowledge that obviously commercial commercial approaches can change over time, but depending on what are perceived to be market demands. So I think we would still have concerns that there may not be sufficient demand for this site to warrant the need for it in this location, given how the site currently operates and how it's evolved over time. Thanks.
Okay, thanks. And is there any other
Yeah, can I just come
that
back
you're
on-
able to?
On one point
Yeah.
on that, just to clarify, when it was me that put those applications together for the lawful development certificate, what we were trying to do there was, because the site was a mixed touring and static site, there were no controls in terms of whether the original permission is the source of the fact that it's an unrestricted site. But what we wanted to do was clarify that we wanted to, rather than have a mix of touring and static, we wanted to make sure that it was clear that the whole site could be used for static caravans. So we did go for 55. That was probably trying to put too many on the site. We acknowledge that, but we settled with the 49. But that was solely to clarify that the caravan park, which is an unrestricted caravan park, can be used to station entirely static caravans, because our client, he operates, his specialism is in static caravans for holiday or residential. So that was what they were trying to do. We weren't trying to change the actual planning permission in any way. That was inherited, the unrestricted nature of the permission. So the 192 was to clarify the number of units. So that's really where we got to with that. But again, I would say that, I find it very difficult to see that the council can say there's a need, but not a demand, I think is what they're saying, that there's a need. There's a need for units. That's clear in the local plan and elsewhere. But if we put the units in here, there's it's the wrong site for them, or there won't be the right demand. I just don't understand that, because somebody having a holiday or booking a holiday on a site is not going to know that there are some residential units on the site. I mean, you wouldn't even be on their radar. So I don't see how the fact that there are some residential units on another part of the site is going to have any impact at all on how well these units will succeed as holiday units. Our client is satisfied from the interest he's having at the moment on this site and others, is that there is and just the knowledge of the industry, that there is a huge demand for additional sort of static and lodge type accommodation. So we're absolutely confident those 10 units will be successful. And that certainly comes from our own little not the most scientific survey, it has to be said, but we've tried to speak to every single caravan park operator in the vicinity, which we did. But of course, a lot of them were reluctant to give us their information. But certainly what we found was there isn't a great supply. And the impression is that the local plan is right, that there does need to be some more units. So yeah, I think our position is we're all agreed there's a need. And where we differ from the council is that we don't see that the residential element of the existing site will have any impact at all on how well the holidays part of the site operates. I think most people who stay there will be completely blind to the fact that there's some residential on the site.
Can I just come back on the maintenance issue? The existing site does already have a maintenance shed there that facilitates all maintenance and general upkeep of the site as it is. And that's undertaken by our client's team on the site.
As the council mentioned about it was an application for a different maintenance building. Was that something different?
There's an existing agricultural building that's included within the application, which could be used for additional maintenance and storage purposes. But at the moment, the maintenance is carried out from the existing shed within the site.
Okay, thank you. Thank you for that. Do you want to come back on any of these points at all? As I don't think I've got any more questions about the need aspect, but you want
No,
to-
no, thank you.
no. Okay. Okay, so if we can go on then to the second main issue, which is about character and appearance. Mr. Taylor, can you just explain how you see the proposal will be harmful to the character of the area?
Yeah, thank you. So obviously the proposal is for 10 sort of holiday lodges, which obviously will be set in that sort of parcel of land to the south of the application site of the existing site, sorry. And looking at sort of the site area and where it sits, it obviously extends out to the east of the existing application of the existing caravan site by quite some degree. And I think, you know, obviously the area itself, when you view the area from, particularly from those public rights of way that were mentioned in the report, both from Hawkins Drove, I think it is, and that leads across the northern boundary across the north of the existing site, and then down the east of the site as well. Obviously, at the moment, the views of that site are taken in accordance with the existing farmland that surrounds it, and obviously the concentration of agricultural buildings that sit adjacent to the caravan park. Obviously, this application proposes 10 holiday lodges, which obviously will need to mitigate the impact of flooding. So therefore will need to be raised by, I think it was around about 700, 800 millimeters off the ground. And obviously they're capable of having internal ceiling heights of up to 3 meters. So by the time you've sort of added those heights up, you're sort of somewhere near to, I guess, 4 meters. So notwithstanding landscaping, they would be visible across from, you know, quite wide views across from the countryside, and obviously in high concentration, 10 in that sort of in that layout proposed. It's considered that obviously, whilst some of the soft landscaping would screen the sort of lower portions of those lodges, nonetheless, the roofs at least would be visible from quite long-ranging views, and obviously the impact of that, particularly given its sort of position relative to the existing caravan park, which is, you know, enclosed already with sort of dense vegetation, this would jut out from that and appear sort of a bit discordant from obviously what's currently experienced, and would be sort of set and appear separate to the caravan park purely because, you know, the way it sort of juts out to the east. So on that basis, it's considered that there would be some significant harm to the countryside because of the scale and the appearance and location of that particular site relative to the existing caravan park and the surrounding farmland and obviously the farmstead to which it sort of sits adjacent to.
And the proposed landscaping along the boundaries, how would that go towards mitigating?
I guess the concern is that how is that reasonably controlled in terms of how high you grow something to screen it completely? I don't think that's feasible. I think, as I said, it would screen the lower portions of those units to a degree, subject to a decent, obviously, maintenance plan, I guess. But the roofs at least would be visible from quite long distances, and I think as I've raised, there is perhaps concern over how reasonable some of that landscaping would function relative to the proximity of some of those units given that the southern boundary is proposed to be quite heavily landscaped in quite close proximity to some of those units. So therefore, you'd end up with quite significant shadowing. But obviously, we're not applying a test of long-term residential amenity. So as I said in the officer statement, it's perhaps more of a commercial concern. But I think the reality of screening that site from long-ranging views, I think, is going to be difficult because of the scale of the units.
And in your view, this kind of accommodation in the countryside, would that appear? Would that be something that would be unexpected?
I think, given that the policies identify the need for campsites outside of settlements, I think there has to be some acceptance that caravans would be, visible in countryside landscapes. Obviously, we balance the impact with that need as well, that justification. But obviously, in this sort of situation, the shape of the site relative to the existing arrangement of buildings and structures nearby, particularly with that area to the east jutting out, it just appears discordant and illogical in terms of its sort of shape. So it's considered that's really where the harm would fall.
And so it's the relationship with the existing site they're concerned about in terms and sort of the way it juts out to the east. Is that?
Yes, that's right. Yeah.
To respond on to some of those points, in general terms, in terms of the impact on the character of the area, but also the point that the council's raised about the landscaping on the southern side and the proximity to the units.
Thank you. We obviously accept that there will be some impact from the development visually, but our main point of contention is really whether that constitutes significant adverse impacts. As you will see from Appendix 11, we've included a number of views from around the site, both from public rights of way and from agricultural tracts that run around the site. I think views from the public right of way that run along the Riverside bank, these would largely be obscured by the existing site and the farm complex. You may get views through the access into the farm complex, but again, not significant and not dominant in the streetscape as suggested in the officer report against the refusal. To the east of the site, you've obviously got the further public right of way and some agricultural tracts. Views from that area will be looking back again towards the agricultural buildings and the existing site. And you wouldn't generally appreciate the small portion of the site that juts out, as the council puts it. We've also got existing boundary hedgerow planting on the site, which was put in when our client bought the site. I think that went in around 2020. When I visited the site again in April this year, those trees were already at 2.53 meters. So the council's concern about trees or landscaping not being able to mitigate the impacts of the views of the caravans, I think's somewhat unfounded. Obviously, Lelandai is not something you typically see in the countryside. That's why we're proposing an additional landscaping scheme, which could be secured by condition, as could its upkeep and maintenance. Standard condition suggests sort of a 5-year maintenance plan, which we'd be willing to accept. And once the landscaping schemes has established, we could agree to remove the ley landi if that's what the council would consider more appropriate. Obviously, the parcel of land itself is dictated by the drainage system that's already in the landscape. So that bounds the site on two boundaries, basically. In terms of the impact on the landscaping on the units, as you can see from the layout, the units are located sort of perpendicular to the southern landscaping, and the main windows would potentially be on the sides. Obviously, you would get a window in the end, in the southern end, but given the light that would be enabled into the units on the other sides, we don't see that as being a significant issue. We are talking about holiday units here, where obviously it's not the same as a permanent residential unit, and levels of amenity will be by choice when you're booking that unit. You'll know what you're booking and whether you want to book into that unit.
So just to clarify, the Leylandii planting that's already gone in, is that on that southern boundary, or I mean, I'll see it when
It's
we've gone
on
to
the
site, but
southern. You will definitely see it on site. It's on the southern
it's on the
boundary,
southern boundary.
southern boundary, eastern boundary, and partially on the northern boundary.
Okay, so I could see when I walked along the Riverside path, and I walked along Hawkins Drove, and then down the footpath from there, and I could see that where the site was, and that there was some planting, but because it was quite a way away, I couldn't see what it was.
No.
So it is all of that planting Leylandii planting. So
Yeah,
Yeah.
that's just demarking the boundary of the applicant's ownership, public's ownership.
and so the proposal then would be to put some more native planting in instead. Is that right?
I was just going to say that I think the idea is there's a scheme that can be agreed, so we can agree a scheme with the council, whatever that is. That could be some additional native planting, it could be to put some planting alongside, and then eventually remove the Leylandii. So the Leylandii was put in to mark a boundary, an ownership boundary, when he acquired the site. It wasn't really put in for the scheme, but obviously it has the benefit of screening this development from day one, which is good. But ultimately, we've always assumed that the planting scheme would be with native species, and there'd be an opportunity to then remove in a few years, maybe at sort of 4 or 5 years points, remove the Leylandii before they get to really big. So that we're still at the position now where we can put in a landscaping scheme, and then we can remove the Leylandii after the new scheme is established. Or it may well be, obviously we don't know what we're going to agree with the council as part of the landscaping scheme, but it may well be that some of the Leylandii gets removed and some native species get interspersed with it. But that's all for agreement. The main point is the scheme will be agreed. That's point number one. And point number two is there's already screening there, so there won't be this the landscape impacts. The impact on views, particularly from the south and east, will not be. You won't really see the caravans, but you can take obviously on the site visit today. When you go in the site, you can take your own view on the extent to which the existing planting will provide a benefit in the short term, whilst the planting scheme that we agree with the council establishes itself.
Okay, thanks for that, Mr. Taylor. I mean, obviously, I'll take my own view about the kind of the wider impact on the countryside. But in terms of the landscaping scheme, have you got any further comments in relation to what's been said about that? And because I know that was something that you had raised concerns about.
Yeah, I think obviously we're looking at landscaping that's gone in and been in for sort of 3 years now. It's sort of grown to 2.5 metres. But by the sounds of it, I think a 5-year maintenance plan as proposed is probably concerning, given that we're obviously trying to avoid long-term impacts, and a 5-year maintenance plan would the sort of the standard arrangement there is that there would be replanting if anything diseased or died or was uprooted within that 5-year period would be replanted, but there would be nothing longer term than that to ensure that long-term impact is maintained. I think that would be a concern for us, but I appreciate we've got conditions to discuss later perhaps. And I think the council would still have concerns that the site wouldn't be sufficiently screened through soft landscaping, or could be reasonably controlled in the longer term through a landscape strategy, without risk of it failing, and obviously therefore no controls being applied. So in terms of potential risk for longer term harm, while short term harm may well be in part able to be addressed through a landscaping strategy, I think long term would perhaps be a concern in terms of how those failed plants, should they fail, how they would be managed and maintained, and whether it's reasonable to secure their longevity for a lifetime of the development. I'm not too sure that's reasonable given soft landscaping, but that may be something we discuss.
Okay. Well, we can. I mean, we might as well discuss this now, actually, rather than because sort of include it as, I know it's a conditions thing, but it's kind of part of this discussion, isn't it, in terms of how a condition, if a condition could satisfy your concerns. So the suggested condition 6 requires a landscaping scheme and detailed implementation programme and long-term management plan. So actually that doesn't specify any kind of time length. It kind of just leaves it to future discussion, doesn't it? Is that something that you think would need to be pinned down a bit more then?
Yeah, I think the concern with how that condition is worded is obviously, we come from a start point as a council that we don't consider that you should be wholly reliant on soft landscaping to mitigate significant harm to the countryside. And I guess the reason why there's not a proposal for what is long term in terms of timescales is that, having regard to the tests of conditions and how reasonable some of those conditions are, obviously the council would probably prefer a lifetime landscape management plan, but I don't think that's perhaps reasonable. But I guess that is would be our starter. Obviously, we have biodiversity plans, for example, that require 20-year management plans. That perhaps might be a bit more reasonable and perhaps aligns a bit more with current ways of thinking, although that may not necessarily deal with the lifetime impacts. But I think, as I say, I think we'd be concerned that a 5-year maintenance plan would perhaps be a little bit too short term to mitigate the long-term impacts of this development.
To come back on that.
Yeah, before I go into the details, I just want to say as a general point, obviously the issue of landscaping scheme obviously would apply to any scheme that comes forward under EMP 8. There's nothing particularly special about this site. In terms of landscape, in actual fact, there's probably this site is a better site than, if it was a freestanding site was to be developed in the area around the Riverside. it wouldn't have the benefit of the screening of the existing site and being adjacent to the existing site. So in terms of landscaping, in our view, this site is easier to manage in terms of landscape impact than a new freestanding site, because it is adjacent to and abutting an existing site. But moving on to the point about the conditions and how long in the future the landscaping can be proposed. I note on the other conditions, the biodiversity enhancements are to be maintained in perpetuity, condition 7. We've got the flood risk measures to be maintained in perpetuity, condition 9. Foul drainage scheme to be maintained in perpetuity. The hydro break outfall to be maintained in perpetuity. Our client has no issue. He put the planting in that he's got in there now. The moment he bought the site to define a boundary, he's got no issue with maintaining planting around the boundary. That's what our client wants to achieve. That's why he put planting in voluntarily when he first acquired the site. So if all these other conditions can be maintained in perpetuity, then this could have a similar requirement at the end of the condition, just like all the other conditions. That would probably cover it, or alternatively, as the council suggested, maybe a 20-year maintenance plan. There's already a requirement for a long-term management plan. If you wanted that to be specified to a 20-year period, that wouldn't be an issue at all.
Okay, thank you. That will be something I need to take a view on if I were to allow the appeal. But does that offer you any comfort? Do you want to come back on any of those points?
No, I would just say that 20 years is better than 5. Thanks.
Right. Okay. Thank you. So unless anybody's got any further points they want to make in terms of character and appearance issues? No? No? Okay. So the council, you'd had raised an issue about the sequential test, the flood risk. And I did want to raise this because I know it wasn't a reason for refusal, but if I did find the proposal to be otherwise acceptable, I would need to make sure that I was happy in terms of the flood risk issue as well. Because obviously it is a flood zone 3 location. So can you explain how the proposal satisfies the sequential test, please?
Obviously, we put for the application forward as an extension to the existing park. In that reason, in applying the sequential test, there's no other logical place for it to go. In our opinion, this is the client's land ownership, and he's got no other land available to put these units on. If you look at the wider flood map for planning for the Littleport area, I think you'll find that flood zone 3 pretty much envelops the whole of Littleport. And it is flood zone 3, but it is protected by the flood defences, which obviously you'll see from visiting the site, is the raised bank on the river. A flood risk assessment says that bank being breached is very small probability, and that's why we've development in that area. So we consider to be acceptable in meeting the exception test and the sequential test.
Okay. You did raise in your statement about the sequential test. Is there anything you'd like to say about that?
No, I think the council's original report identified that the sequential test hadn't been undertaken as part of the FRA that was submitted. Land ownership is not essentially a consideration for sequential tests, but nonetheless, I think the council accepted that if this were to be approached on the basis of an extension to the existing caravan park, then it would make logical sense to abut it. it was noted that there was an area to the north of the site that's all flood zone 1, but the council did their own bit of research at the time of making the decision, and that didn't appear to be available at that time. So it was considered that, on the basis that it was proposed to be an extension, and that there were no other areas of land around the site that appeared to be reasonably available at that time, that the council was satisfied that the sequential test had been passed. I think, obviously, more recently, as sort of Nick mentioned, there was concerns raised as to whether this was a whole new venture, in which case the sequential test would perhaps be reconsidered. But I think we've had it clarified that the intention is for this to be an extension. So I think on that basis, the council would not really want to raise any further concerns over the sequential test, and they're satisfied in terms of the exception test that the development can be made safe without causing flood risk elsewhere, subject to the condition requiring a bit more detail or confirmation about the hydro break on the drainage strategy.
Okay, thank you. So you're happy in terms of the sequential test. In terms of the exception test, then, I had a query about the flood risk assessment. And again, this kind of partially comes into the conditions discussion as well, actually, but the flood risk assessment sets out some proposed mitigation. And I just wanted to clarify that a little bit. In paragraph 8.19 of the flood risk assessment, it says it's recommended that flood resilience measures are considered for the site, and it should be noted that units are typically raised approximately 500 to 700 millimetres above surrounding ground levels. But I wasn't sure exactly what the flood resilience measures were, and whether that was suggesting that the units need to be raised by that much, and that needs to be a clear requirement if the development, in order to meet the exception test, because it seems slightly sort of unclear, given that the suggested condition is saying that the flood risk mitigation measures as set out in the flood risk assessment should be implemented. I just wasn't entirely clear, if you start with that condition, what exactly those measures would be.
Yeah, I think the measures set out in the flood risk assessment are obviously to raise the floor levels of the units, like 600 to 750 mil, which is usually sort of a standard for a caravan. They're usually located on such bases. So that would be our intention, to site them at that sort of level. In addition to that, we obviously have the flood evacuation plan, which would be in place and obviously made available to any occupants of the site. So those two elements combined would form the mitigation. I think the flood risk assessment demonstrates that there is a very low probability of flooding just due to the flood mitigation measures that are already in place. And I think if this site floods, then obviously you've got the existing site that's in danger, and also Littleport itself, because it's all in the same sort of ground levels. So we think with the measures we've put forward, the site could be safely occupied and operated.
Okay, thanks. It was just whether it's clear exactly what the requirement would need to be. That was my query really about that. I don't know if, I know this wasn't anything that you raised particularly, Mr. Taylor, but
Yeah, thank you. I think the only thing I would add to that, having regard to sort of how the Environment Agency would normally seek to secure resilience to these kind of developments, would be to sort of have a scheme as to how the units are anchored to the ground, which appears to be missing from the FRA. And I think, you know, as a council, we've omitted that as well in the conditions schedule. So I think we would probably want to add, and I think it's a reasonable concern in that, you know, perhaps the condition needs to be specified in terms of those floor levels, although the FRA does set out what the intention is, but there is some flexibility in what the FRA sets out. So perhaps it does need to be a bit more precise in terms of what's required. But also, obviously, I think we would probably want a scheme to understand how those units are anchored to the ground. Again, pretty standard condition, I think. So that's something I think I'd probably suggest.
Okay, thank you. But assuming that those things could be resolved, then you're happy in terms of exceptions. Okay, thank you. Right, so that was those two matters. Oh, there was something else that needed to be, some missing information in terms of drainage as well that you'd mentioned.
Yes, I think it should be quite a simple matter. I think it was just the orifice diameter for the outfall was essentially undersized to what the lead local flood authority would otherwise prefer for that site. So I think they'd suggested that a large orifice diameter is utilised. And I think manically try and find the condition schedule. I think there was reference to that in one of the conditions. Yeah, so condition 11, proposed condition 11 sets out full details of the hydro-break outfall control, because the lead local flood authority had essentially suggested options there. So either a sort of improved hydro-break outfall mechanism or a perforated riser, and obviously it's for the appellant, I guess, to determine what they would consider would serve that development better. There seems to be options from what I gather, but I think we just want certainty and clarified that's agreed and implemented appropriately prior to any occupation. Thanks.
Okay, thanks. Did you want to come back on any of those points about the conditions?
Yeah, there was a lot of discussion with the lead flood authority between our drainage consultants and them directly. We made significant changes to the scheme to accommodate the needs of the drainage authority. And I think we just got to a point where obviously the application was to be determined. So we'd be more than willing to accept the condition. It was only a minor point. And I think if we'd had a bit more time, we could probably have resolved it during the application, but it is something that can be easily resolved from our point of view. With regards to anchoring the units, that's not a problem. We'd be willing to accept a condition in that regard. It's very often the case where units are located in potential flood risk areas, but obviously with the Environment Agency and the Flood Authority not having concerns in terms of the flood risk, we've just not pursued that through the application. That was all.
The only other issue, the query that I had in relation to that was in relation to the access. If there was if the bridge onto the main part of the site in the event of any breach or failure wasn't available, was there a secondary access through the existing farm? That's outside of the appellant's ownership, is it? I was just wanting to make sure that could be ensured that would be open.
Yeah, the appellant has right of access across that, and it would only be used in terms of emergencies, but there is a right across that land.
Yeah, okay, thank you. It's just, you want to make sure that was available and if it ever needed to be. Okay. So I think actually because we've talked about a couple of these conditions as part of the discussion. There wasn't many other comments I had in relation to conditions, which the only query I had really was the policy EMP9 sets out some holiday and season occupancy conditions. Which it says would be placed on new unserviced holiday accommodation. Not all of those points have been proposed in the suggested condition. I was just wondering why that was, and whether you'd normally ask for. Sorry.
If you could give me a moment. Okay, so condition 4, I guess, is that proposed condition 4
Yeah.
in terms of restricting?
Yeah.
Yes, I think this has sort of come about through sort of, I guess, other developments that we've approved and sought to control. So I guess it's this condition's arisen as probably from a consistency point of view from the council. So I take it may have moved away somewhat from the policy. Yes, I think. Yes, I think perhaps I say I'm not too sure where that condition has arisen, but it may well be from other developments that we've approved. But certainly, I would probably agree that it perhaps doesn't meet all of the requirements of EMP9. I think in terms of EMP9, which requires, obviously the first criteria appears to be met through this condition. In terms of availability, that doesn't seem to be on there, which, as I say, I'm not familiar with that being in our conditions to date. And I think in terms of maintaining an up-to-date register of lettings, that's probably a standard procedure, I would have thought anyway, for any business operating a caravan park. And I think undertaking a monthly management check of the register, I believe there are probably appeal decisions which would perhaps consider that to be perhaps a bit onerous. But certainly I would say that condition 4 may need expanding on slightly. I'd be happy to quickly have a look at that to see whether or not, in discussion with with yourself and the appellant, whether we could review that condition to see whether it needs enhancing a bit in order to make it a bit clearer.
Yeah, it's just because, it kind of initially struck me that, you got this policy saying we should cover these things, and then and then the condition doesn't, well, I mean, it does cover the first issue, doesn't it? But and yeah, perhaps some of the things are more onerous than they needed to be, but the second point, it shall be available for commercial holiday lets for at least 140 days a year, and no let must exceed 28 days. Is it? I suppose perhaps is this more concerned with existing accommodation that's being converted to holiday let? Is that what that was?
Yeah, I think it's
Perhaps it was.
it's potentially a bit of a catch-all
Yeah.
policy. I do have an example in front of me here, which you know I'd be happy to suggest if and I could maybe get that quickly printed out and circulated if you wish as an update to condition 4, unless obviously you wish to consider that further yourself, should you feel that you could allow the appeal. But
what do you want to read it out?
So the condition example I have here sets out, notwithstanding classes C2, C2A, C3 and C4 of the schedule to the Town and Country Planning Use Classes Order 1987 as amended, the development hereby approved shall be restricted as follows. A, the use shall be to provide holiday accommodation only and shall not be used as permanent unrestricted accommodation or as a sole or primary place of residence. B, that no individual or individuals, families or groups shall occupy the holiday accommodation for more than 1 calendar month consecutively and shall not return within the following calendar month unless it says unless otherwise agreed in writing, but I don't consider that perhaps an appropriate addition. And C, that a register of lettings occupation shall be maintained at all times and shall be made available for inspection by the LPA upon request. So it's perhaps a little bit more detailed than what we have here, but obviously nonetheless seeks to essentially control permanent occupancy.
Okay, thanks. Do you want to comment on that at all?
My initial comments are, I think most commonly used now throughout the country for holiday use, because there's been quite a few appeal decisions, and we've been involved in a number of those ourselves, which is not the standard condition that tends to be used these days by almost all councils is holiday use only, not to be used as a sole or main residence, and the keeping of a register, not to be made available. The bit of that condition that seems to always fall away, and we've done a number of appeals on conditions to remove the stay period, as the inspectors have said. We've been successful in every appeal we've run on that. Inspectors have said consistently that that's too restrictive, because if somebody says it's going to stay for 28 days, that rules out, for example, somebody might want to stay 6 weeks throughout the whole summer holidays. Situations like that makes the businesses less successful or even contribute to the economy. So we've been involved in 3 or 4 appeals in the last few years on that point. So that's the bit that always seems to fall away. But certainly the keeping of a register, to me, seems to be entirely acceptable, because it's all very well the conditions saying it should be holiday use only, not to be used as a sole or main residence. But it then becomes very difficult for the council to actually enforce it if there isn't some information that's readily available on request. So to me, that element is reasonable. So we would just question the sort of slightly arbitrary nature of the how long people can stay, which hasn't. So I assume that's the reason why. I assumed that was the reason why the council was putting forward the condition they did, because I know you mentioned appeal decisions earlier on, and I know I've been involved in several, not necessarily in this council area, but elsewhere in the UK, on that sort of overly restrictive in terms of managing how long individual occupants can stay, which is a sort of the council getting very involved in almost bookings, which isn't ideal for a business.
Yeah, so the inclusion of keeping a register so that you were able to actually see how the site had been used. Yeah.
Yeah, I mean, obviously, every operator will keep a register, because if they're taking bookings and people are staying there, they would know that they've got the barrier on the site for a start. So you can't get in without getting yourself a card to lift the barrier. So the operator will, almost all operators will know who's on the site, and they can provide the dates when they arrive, the dates when they leave, and they can provide their name and address. And that's the key thing. So the council can then take a view as to, looking at that information, whether is complying with the condition. I think that's a useful addition, because the condition as it stands doesn't have any way of the council actually easily finding out, other than just walking around and seeing whether you've got some of the obvious hallmarks of permanent residential. But at least if you're keeping a register, you know who's there. Then the council will just ask for the information.
So, comment on that at all? That
Yeah, I think we'd be happy with obviously the restriction first set out as is set out currently in terms of its use. Obviously, the register of lettings. I think we'd be satisfied with that in terms of how we can monitor the site. Obviously, I take on board the comments regarding the return period. Obviously, that as set out in the proposed condition, there kind of aligns with EMP 9. But I take on board that there's probably likely to be some appeal decisions that would indicate that isn't perhaps appropriate in this day and age to restrict occupancy to 28 days or a month, whatever it may well be. So I think we'd be satisfied that on the basis that we've got a register, that second proposal for the return period wouldn't be necessary.
so keeping a register and making that register available at all reasonable times to the local planning authority. Yeah. Would you'd be happy with that then?
Yes, that's fine. No.
So I didn't have any other questions about conditions. Only just to clarify that in terms of the Swan and Goose impact zone, I understand from my reading of the information that it seemed that there was no concern about any potential impact on the SPA, or need to do HRA.
No, I think we're satisfied that there would be no impacts that would need addressing. Thanks.
Right. So does anybody want to make any other comments on anything that we might have said before we close the discussion this morning? No. Okay. And can I just confirm there's nobody wanted to make an award of or application for costs? Again, no. Okay, great. So I think it would be useful to go and have a look at the site, to actually be able to go on the site. As I say, I'm going to close the hearing, so this would just be to have a look and not to have any further discussion. So I would need the appellant there to provide access. And if you're happy for me to do that on that basis, then you don't need to come, but if you want to come in to ensure that it's all open and transparent, then it's up to you.
Yeah, I think we'd be content if you want to go on the site yourself to have a look around. I don't, you know, unless you consider it's beneficial for us to be there, I think we'd be happy for yourself to go.
So I could just do a normal access required site visit, like for a written reps application. We'd just have somebody there to provide access if you're happy with that.
Yeah, happy with that. Yep.
Sure. Yeah. Okay. So we'll do it on that basis then. That's okay. If that's okay with you as well. Let's say it's literally just a case of just being able to have a look into the site and no further discussion because we've done that. Okay, so could we meet there at 12:30? Would that be okay? If I just park in the actual caravan, can you drive into the caravan site itself? Okay, great, thank you. So 12:30, sure, that's okay. Great, in that case, I will close the hearing now. Thank you for your contributions, and I'll see you at 12:30 at the Caravan Park. Thank you very much.